of a protest because they only tag the posters which can be taken off, which is quite polite. Anyway, okay, so this is our second panel, which will deal with what will be in the book, the third part of the book, devoted to what we call the structure of public debate. That is the different kinds of forums, of discourses, of agents which contribute in implementing public debate. And the general question in this section is to ask how the general freedom of expression, how the general right to free expression happens to be differentiated and to find various and plural kind of legal implications depending on the identity of the agents and the kind of discourse and on the type of forums. So what physical or virtual arenas of communication should be identified as forums, as public or private forums for public debate? How is the access to these forums and their use regulated, and how should it be regulated? Which discourses or kind of speeches are considered to be part of democratic debate? We've discussed this already a little bit in the previous panel. And do specific kind of discourse enjoy special status or are associated with specific kind of obligation and constraints? And finally, which agents should be recognized as particularly essential because of their function to achieving public debate? Elected officials, journalists, activists, whistleblowers, and so on and so forth. And are they and should they be subject to specific legal regimes, protections, or obligations? So as I mentioned, unfortunately, Ursula Jaschelat, who will deal with this last chapter, wasn't able to make it today, but we'll have the pleasure to listen to Johannes Masing from the Albert-Ludwigs-University of Fribourg, who is also a former justice of the German Federal Constitutional Court, and from Patrick Wachsmann, professor at the University of Strasbourg. I think Patrick's speech will be in French, but you have the text in English in the shared Dropbox. So I'll start by sharing Johannes' handout. Can you see the full page? Yeah. Pierre, do you see it?
I cannot, but I have it, of course.
Yes.
Yeah.
Now I can see it.
Okay, great.
Okay.
So the floor is yours, Johannes.
Thank you. Thank you very much for your invitation and for your circumspect preparation of this conference. It's really a great project, and I like it for its transnational approach. We have not just to discuss and develop our internal debates and understanding of freedom of expression, but we have to expose its basics and underlying assumptions to constitutionalists and philosophers of other countries. And I think it's very important, and I'm convinced we all are very much captured by our internal perspectives. I think there are few academic fields as national as constitutional law, and I'm concerned of this. If we want to preserve our liberal foundations of our societies, we have to get together much more than we do normally. And such projects may help overcome such boundedness. One other preliminary remark, I'm disappointed in one respect. I hope to discuss the subject with you in presence, to have a French dinner after that together, to have an informal exchange at the margins of our topic and beyond. and I hoped to get to know you as persons. It's a pity that this doesn't work. I think we need to meet in person. We don't live in a virtual world, but in a real world. So let's hope this will soon be possible again. And let's hope that we will not have become too torpid and lazy until then. So, what is my article about? In my written article, I tried to present a synoptic view on our understanding of freedom of expression in Germany. I refer to German constitutional case law, but not discussing its internal conclusiveness, but in order to expose its general structures and assumptions. My aim is to make our approach understandable, to contribute to a common understanding of the problems we are confronted with. In doing so, I refer to a broad understanding of freedom of expression. I do not reduce freedom of expression, distinguishing it from the specific other fundamental rights in our German constitution in this field. But I refer to the broad sense of this idea in the international context. However, this is not guided by the assumption this all is the same. In the opposite, presenting a broad scope of different fields of freedom of expression, I want to show that we deal with very different issues and that they just require different legal answers in the interpretation of this freedom. Just to give you an idea of some of the distinctions I deal with in my articles. First of all, it is important that freedom of expression is protected against state action, or if it has to be secured between private persons. Then there is a difference of freedom of expression means free speech, free political speech, we talked already about that, or private speech. If it means freedom of art, freedom of assembly, freedom of press, of broadcasting, or of science, there are much more distinctions. I take up some basic lines of the case law of our court, extrapolating different consequences and requirements, very different consequences. You will find that we even deduce complex institutional and regulatory requirements from fundamental rights. However, it is not possible to present or even to summarize the content of my contribution in 20 minutes. Anyway, my article had become too long and I had to cut it in 2 articles. So in this presentation, I can only focus on a small point. I will only present a small extract, to be true, a snippet. The freedom of expression on the internet. And even there, I will focus only on the question of how assessing the different conflicting fundamental rights of freedom of expression in the context of private service providers. Indeed, this refers less to explicit case law of our court. There is some, but little, but to the basic lines of understanding the fundamental rights in this jurisprudence. In a way, it's a conclusion of the court's case law, perhaps even a little bit of summary, in respect to future challenges which we all share. So I start with my point 2, putting the problem in the framework, the multipolar relations between private actors. Freedom of expression on the internet is based on private infrastructures. This produces a new field of powers which the interpretation of freedom of expression must take into account. The dissemination of opinions here are based on services that are provided by private actors. It's ultimately private providers who decide whether a statement can be published or not. Freedom of speech is so put in multipolar legal relationships. The basic type is a triangle. Those expressing opinions, let's call them the speaker, the affected parties who are possibly injured in their fundamental rights, and the service providers. In this triangle, decisions on access and exclusion to infrastructure are decisive for the freedom of speech. They decide about freedom in real life. Just to give some examples. Our court had to decide on a case when Facebook shut down an account regarding a right-wing extremist party during the European election campaign. It thereby was depriving this party of its main electoral advertising opportunities. To give other example, the civil courts had to decide on. Social networks sometimes are excluding inappropriate statements. Can they do it at will? Maybe algorithm-based? Or news portals have discussion forums that they are monitoring and they bar extreme comments. Have they to do it? Can they do it? And we have many disputes about the legality of statements in rating portals. Students rating their professors, patients rating their physicians. Here the portals decide, or to what extent can the portals decide about the opinions of the persons participating in this rating process. And to give another last example of my court, we have the question if search engines are subject to restrictions when indexing web pages. The question the ECJ also had to deal with. Can or must search engines be requested not to display illegal web pages, for example, at the request of an injured person, at the request of the state? And last but not least, we all know the example, the shutdown of the Twitter account of the US president. These are very different examples, of course, but they just illustrate the importance of private providers for the reality of freedom of expression in our world. In practice, these questions are normally brought before civil courts at first and solved primarily by rules of civil law. However, in a German perspective, questions of fundamental rights protections are always lurking in the background. And even more, all these cases can and have to be possibly construed in a fundamental rights perspective. So I arrive at my third point. The constitutional guarantee of freedom of expression in private relations, because all these are private relations, of course. Our point of departure is fundamental rights also apply in respect to private relations, and above all, to freedom of expression. In Germany, there is no doubt about it, and it's part of the basics of the fundamental rights protection. I think that's in Europe in the whole an approach in this sense. And I think it's indeed vital if we seek to preserve freedom of expression as a meaningful fundamental right in our society. However, effects and legal consequences of fundamental rights are very different when applied to private relations. Freedom of expression produces different protection in respect to private relations than in respect to the individual confronted with state action pursuing general collective interests. To understand this, let's first have a look at the fundamental rights protection against state authority. Insofar as fundamental rights and freedom of expression protect the individual against state measures pursuing general collective interests, they provide asymmetrical protection. The citizen enjoys the presumption of freedom. The state must be held accountable. Therefore, interferences of fundamental rights must be limited as much as possible. They have to be defined. They have to be legitimized by law. They have to be held substantially reserved. The whole idea is protection guided by the idea of minimization of interferences. And regarding to freedom of expression, we are very strict in this respect, very much stricter than often, above all, Americans think. Every political idea and political speech, however radical, may be expressed, even if it could never be legally put in practice. We have an eternity clause where there are limits even for amendments of the Constitution. But even ideas which can never be legally changed, even by amendment of the Constitution, can be expressed in the perspective of freedom of expression. So left and also right-wing extremists, religious fundamentalists, even neo-Nazi ideas can be expressed according to our jurisprudence. There are some limits in respect to the Holocaust, that's true. I won't go into it here, but normally we are very, very broad. And in principle, I would say there is no content-based limitation. Only modalities can be reduced. So we are very close to the US approach in this point. So, but to summarize, the idea is asymmetric freedom against the state. In contrast, the idea of asymmetric freedom cannot be understood as governing the relationships of private actors. Citizens face each other as equally free persons. The relationships, the legal relationships, are of symmetrical order. In principle, no free person is accountable to another, of course. So, fundamental law protection means something different. It is guided not by the idea of minimization of interferences, but of reconciliating conflicting individual rights and interests. The aim of fundamental rights protection is to preserve freedom and fundamental rights on both sides equally. Here it's all about securing a balance of equal freedom, imposing limits on either side. And consequently, content-based limitations are generally possible here. You cannot tell anything about your neighbor, and you can't do it in the United States neither, because they have libel jurisprudence too. So all this is based on the assumption that fundamental rights and freedom of expression are legal ideas, constitutional principles, which have to be brought in a balance in order to secure mutual freedom. Nevertheless, thereby too the problem of asymmetric power also here plays a defining role. The more powerful private actors are, the more they are bound by fundamental rights of others. Fundamental rights protection has to counteract imbalances. Consequently, fundamental rights may impose requirements just as strict, maybe even stricter than when facing public authority. And for the powerful international service providers, this may become relevant. So I I arrive at my fourth point and will come back to the triangle on the internet. Service provider, speaker, affected person. In a fundamental rights perspective, everybody is entitled to fundamental rights. But which ones? That's easy for the speaker. The speaker can invoke freedom of expression, of course. The affected person, that's not very difficult neither. The affected person has its personality rights. Not only maybe property rights if business secrets are concerned, but normally above all, these are personality rights. It is more difficult for the rights of the providers. What fundamental rights can the providers invoke? Sure, they have the economic fundamental rights, freedom of business, freedom of profession, maybe property. But can they invoke freedom of expression? This is at least doubtful if they just offer a forum for the exchange of opinions by third parties without having own interests of dissemination of opinions, and if they are just driven by commercial interests. In Germany, we have contradictive case law in this question. So, for example, rating portals are protected by freedom of expression following the jurisdiction of the Federal Court of Justice. That's the highest court for civil affairs. On the other hand, search engines are not protected by freedom of expression following the jurisprudence of our court, the Constitutional Court, and also the ECJ. It's a wide field. I cannot discuss this in the depth. And anyway, what is important, we have to analyze what interests are at stake. And one thing is certain, even if we accord the freedom of expression to those host providers, mere business interests have less weight than disseminating opinions. So to go further, all of these rights, freedom of expression, personality rights, freedom of business, maybe freedom of expression too, have to get in a balance. As I told you, they are legal ideas, and the legal ideas have to get a balance so that everybody has had freedom in this balance. But so even if we deal with broad constitutional principles, this doesn't change anything that fundamental rights are applicable law. They are binding all branches of the state immediately. So in first place, they have to be enforced by the legislator, who has to provide adequate laws and regulation. And then it is thereby controlled by the Constitutional Court, who can control it, but who can even push it if the legislator doesn't act. And when applying the law, the regular courts have to make an interpretation guided by the fundamental rights of the respective parties. So to end this, let's go a little bit more in details in the triangle. I open the first point, freedom of the service providers and freedom of the speakers. One fundamental issue is the freedom of the service provider vis-à-vis its users. Pardon me. The Federal Court of Justice, that's the Court of Civil Affairs, had a basic case in this respect. It was a case about Facebook. We all know Facebook provides an open platform for the exchange of opinions without intending to disseminate specific views of its own. Facebook deleted statements which is considered incompatible with its corporate guidelines. So the court had to decide on the question, is Facebook bound by the freedom of expression of its users? And if so, Is it bound in a state-like manner? That means made only by statements that are illegal under the law of the land. Facebook, as a private company, claimed the right to impose stricter requirements. In order to promote feel-good atmosphere for the users or to avoid liability risks, it arrogates the privilege to ban posts at will, and it demands the right to block and to delete every statement it considers unnecessarily polemical or aggressive, even if they do not reach the high thresholds of punishable incitement of masses. The Federal Court of Justice tried to conciliate a balance. On the one hand, the fundamental rights of the users must be considered and, to a certain extent, respected by the providers. On the other hand, providers have their own fundamental rights. They are not bound in a state-like manner. The result? Their terms of use mustn't provide for an arbitrary exclusion of undesirable political opinions. But they may define limits of freedom of expression on their platforms in their own business interests, as well as in the interest of their users. But if they do so, they must have a reason. They must do it in a transparent and foreseeable way, underpinned by procedural rules. The question how far the social networks are bound by fundamental rights is very controversial. Some lower courts went further and sought to bind such platforms at the same rules as the state. And indeed, this can be argued easily, referring to companies with a dominant position in the market. I cannot discuss these questions, neither here. But I have to admit the solution of the Federal Court of Justice had at least very good reasons. But nevertheless, if this view prevails for all host providers, including market-dominant companies, this can have far-reaching consequences for the freedom of expression. On the basis of this decision, freedom of expression may be considerably reduced by private decision. Moreover, this can be promoted by means of nudging by state policy, though the state itself constitutionally could not enforce such restrictions. And it was the case by Facebook in these circumstances. Aside from that, such standards of international companies are likely to incorporate the moral concepts and limits of freedom of expression of other countries. This further will limit the range of possible expressions. And in the long run, there is so a risk that freedom of expression will be reduced to a moral mediocrity of virtuousness and common sense, something I've always fought against in the court and in my writings. Admittedly, at the time being, it may help to counteract the current brutalization of political debate. And for doing that, perhaps it is inevitable. However, it shows how freedom of expression is fundamentally changing and becoming dependent on the service provider. They can and will more and more replace the democratic legal standards by private corporate standards. So I have left some time for my last point, that is another conflict concerning the relations between provider and persons which are affected by statements published on such platforms. This deals with the reverse question: to what extent must the host delete statement off of the internet in order to protect the rights of third parties? Here too, the problem mainly affects service providers that only provide platforms for the publication of third-party statements. This too must be considered under fundamental rights perspective. The fundamental rights of the provider has to be balanced with the fundamental rights of those affected. In other words, the activity of the provider needs to be balanced by a certain responsibility securing the fundamental rights of third parties. The creation of such a balance is primarily in the responsibility of the legislator, and there are many solutions. Currently, the law exempts the host providers from comprehensive attribution and joint liability for the content posted in the platforms. We all know Section 230 of the Telecommunication Act in the US, or the Article 12 to 15 of the e-commerce directive. So providers are not obliged to actively control their platforms. But even so, they at least have to remove the statements when right violations are reported by injured persons. And in my opinion, this legal status is likely to have a fundamental rights score, of course. The legislator can impose very different obligations on the providers, and he had a wide scope of design. Active monitoring obligations, as we know them from the copyright law in the UA and the EU, or obligations to enforce criminal laws, as in the Network Enforcement Act in Germany, can possibly be imposed upon providers by law. But the legislator has carefully to analyze the opposing rights and to bring them to a meaningful conciliation. Under the supervision of Constitutional Court, it has to create this balance. But there's one important point. In creating this balance, we mustn't forget the fundamental rights of the speakers whose statements are to be deleted. It's all above here that freedom of expression comes in. If a provider is obliged by a court to block a statement in respect of its content, it's ultimately a sanction against the speaker. But if a provider is doing so on its own account, this also limits the freedom of expression of the speaker. If we understand fundamental rights as legal principles, which are also shaping the relations between private persons, we have to put this in balance. And we have to impose obligations on providers in order to protect third parties, but the freedom of the speakers also has to be taken into account equally. It's the triangle. And the last point I would quickly mention, because it's very important, this is
Johannes.
Yeah.
I'm sorry to press you, but if you can conclude.
Yeah, I come to an end. I'm really
okay. Great, thank you.
You'll see I'm already at the
sure.
Almost the last point, but that's the last very important point. If you look at not only at the possibly injured person, but also at the speaker, we need procedural safeguards. The multipolar nature of fundamental rights must be reflected in the design of procedures and legal protection. Particularly, a fair hearing is mandatory in this respect. And so, the Federal Justice recently decided, I quote, when a social network removes a statement from the network, it must inform the person concerned immediately, provide the reason for doing so, and offer an opportunity for them to offer a statement leading to the possibility of again making the removed statement available. And our legislator also has amended the Netzwerkdurchsetzungsgesetz in this sense, and the draft of the European Digital Service Act anyway is distinctly aware of the freedom of expression of the speakers. So I stop here. That's only a minute part of my written articles, and these articles take up only a minute part of the challenges ahead. But I think this is the internet is one big challenge we have to share, and it's an international challenge because we cannot resolve these problems only on an international basis. And the fundamental rights, the freedom of expression, has to be taken in account if you want to preserve our liberal foundations of our society in this new environment. And I think it's one point we possibly can discuss to go on, and this to get together, to get to a common understanding, and to preserve this idea of fundamental freedom of expression. Thank you.
Thank you so much, Johannes. Thank you very much. On a personal note, the building I'm in is being evacuated, and there's a student sitting in the courtyard, not unlike the one we put on the poster for the conference. So if I have to leave at some point, please excuse me, and Pierre will take over. We move on to the next presentation in this panel by Patrick Wachsmann. Patrick, I think you'll speak in French. Do you want me to put on the screen the English version of your article and to go along as you speak? Okay, so go ahead and I'll say it.
Merci beaucoup. Alors, je voudrais d'abord exprimer mes remerciements à Charles et à Pierre pour m'avoir invité à ce passionnant colloque. Je regrette, comme Johannes à l'instant, qu'il soit seulement virtuel, mais bon, on fera mieux la prochaine fois, espérons-le, et le virus nous laissera enfin nous voir. Je voudrais m'excuser auprès de tous et de toutes pour le fait que je m'exprime en français. Je me sens vraiment beaucoup plus à l'aise en français et très mal à l'aise en anglais. Donc, pardonnez-moi, j'espère que grâce au texte, vous pourrez à peu près suivre. Le choix des alliances après des élections, la corruption des institutions, l'histoire du pays, et notamment le jugement que l'on peut porter sur tel ou tel dirigeant de ce pays, la chasse aux phoques, la qualité des soins dispensés dans une clinique de chirurgie esthétique. A priori, le point commun n'est pas tout à fait évident. Dans la jurisprudence de la Cour européenne des droits de l'homme, il y a un point commun entre toutes ces questions, si diverses soient-elles, et ce point commun, c'est justement l'idée qu'il s'agit de questions d'intérêt public ou de questions d'intérêt général. La terminologie flotte un peu ici, mais on peut tenir cela pour indifférent. Je ne crois pas qu'il y ait un emploi très strict des termes par la Cour en la matière. Ce qui est clair, c'est que ces termes ont été choisis par la Cour pour exprimer le lien précisément entre la liberté d'expression et les valeurs de la société démocratique. Sur la nécessité, et il est frappant de constater ici la similitude entre ce que dit la Cour à partir de son arrêt fondateur pour la liberté d'expression, qui est l'arrêt Handyside contre le Royaume-Uni de 1976, la continuité entre cela et la conception de Karl Popper de la liberté d'expression et de la société démocratique. Ce que la Cour veut faire, en insistant sur l'importance de la clause de nécessité dans une société démocratique, ce qu'elle veut faire en parlant de pluralisme, de tolérance, d'esprit d'ouverture comme caractéristique de la société démocratique, rejoint tout à fait ce que Karl Popper désigne comme open society, comme société ouverte. La société fermée, à l'inverse, c'est celle dans laquelle il y a des questions qui ne peuvent pas faire l'objet d'une discussion, qui sont placées hors le champ de la discussion publique, ce qui fait la force, dit Popper, de la société ouverte, c'est que tout peut y être discuté. C'est qu'il s'agit là d'abord d'une manière de s'assurer qu'on pourra résoudre par le dialogue et pas par la violence les questions qui déchirent la société. Lorsque la Cour européenne des droits de l'homme, dans une des nombreuses affaires relatives à la question kurde en Turquie, en ce qui concerne la liberté d'expression, dit ceci, je cite, L'une des principales caractéristiques de la démocratie réside dans la possibilité qu'elle offre de résoudre par le dialogue et sans recours à la violence les problèmes que rencontre un pays, et cela même quand il dérange. La démocratie se nourrit en effet de la liberté d'expression. Elle exprime quelque chose que Popper aurait pu écrire quand on prend The Open Society and its Enemies. On a des termes pratiquement équivalents. Comment apparaît dans la jurisprudence de la Cour cette idée de question d'intérêt public, de débat d'intérêt général? Cela se fait assez progressivement au hasard des saisines, comme toujours pour une juridiction, et notamment pour une juridiction qui commence son travail. En ce qui concerne la liberté d'expression, on est dans les années 1975. La Cour est d'abord saisie de questions qui ne sont pas des questions politiques. Et donc, elle va faire prévaloir cette idée que le débat sur les questions d'intérêt public doit être aussi large que possible. Elle le fait non pas dans l'arrêt Decide, qui, entre parenthèses, n'est pas un arrêt libéral et qui est à beaucoup d'égards un arrêt en trompe-l'œil par rapport au reste de la jurisprudence de la Cour. Elle le fait d'abord en 1979, donc on est encore plus tard dans le temps, dans l'arrêt Sunday Times versus United Kingdom numéro 1. Il s'agit de savoir si un journal du Royaume-Uni peut se voir enjoint par un tribunal de ne pas parler d'une affaire, l'affaire du procès de la thalidomide, parce que cette affaire est pendante devant les tribunaux et qu'il n'appartient pas à la presse d'interférer avec des questions qui sont soumises aux tribunaux. La Cour insiste sur le fait qu'il s'agit d'une question d'intérêt public et par conséquent qu'il doit y avoir en la matière une large possibilité pour la presse de participer à la discussion, y compris donc lorsque l'affaire n'est pas encore jugée, et que le risque qu'il y ait des interférences avec l'œuvre de la justice sont des risques secondaires par rapport à la nécessité de permettre une très large discussion dans l'opinion publique des questions qui sont en cause dans ce procès, à savoir l'attitude de la compagnie pharmaceutique qui avait diffusé la thalidomide, son attitude dans le procès, son peu de soins des victimes, etc., etc. Question qui, malheureusement, reste d'actualité. Ensuite, il s'agit d'une affaire concernant le service de nuit des vétérinaires à Hambourg. On est un cran en dessous dans les questions d'intérêt public. Et ce n'est qu'en 1986, donc 10 ans après Decide, que l'on pénètre sur le terrain qui nous paraît le plus naturellement corrélé à l'idée d'une société démocratique, d'un débat démocratique, à savoir le débat politique. Le journaliste requérant, Lingens, il s'agit d'une affaire Lingens contre Autriche, jugée en 1986, Lingens avait parlé en termes très durs de l'attitude du chancelier autrichien de l'époque, Bruno Kreisky, en relevant qu'il était prêt apparemment à faire alliance avec n'importe qui, y compris avec un ancien SS qui revendiquait avec fierté ses exploits militaires durant la Deuxième Guerre mondiale. Et il trouvait que il avait écrit que l'attitude du chancelier était indigne, et il avait été condamné pour cela pour diffamation sur plainte du chancelier par les tribunaux autrichiens. La Cour a estimé qu'il y avait la violation de l'article 10, que la possibilité de s'exprimer sur des débats politiques doit être sauvegardée dans des conditions qui ne sont pas compatibles avec une condamnation de ce type. Il s'agit, dit la Cour, de questions politiques d'intérêt public pour l'Autriche. Remarquez ici donc que les questions politiques ne sont qu'un aspect des questions d'intérêt public. Elles ne sont qu'une illustration de ce qu'elles peuvent être. J'en viens à un deuxième point qui est la deuxième partie de mon article. C'est la question de savoir ce que recoupent les questions d'intérêt public. Alors, il est clair qu'elles recoupent les questions politiques, en particulier la critique du gouvernement en place, la critique des dirigeants politiques, la critique de ceux qui veulent, en se présentant aux élections, accéder au pouvoir. Là, il est assez clair qu'il doit y avoir, dans une société authentiquement démocratique, une latitude très grande pour chacun d'exprimer ses vues. Il y a ensuite ce qui concerne les institutions publiques, parler par exemple de la corruption de l'appareil judiciaire ou de la corruption des dirigeants nationaux ou locaux. C'est évidemment une question qui, dans une démocratie, doit pouvoir être soulevée. On est donc dans la matière, par excellence toujours, de la question d'intérêt public. On est dans le noyau dur, je dirais, à l'évidence de ces questions. Si on ne peut pas parler de ces problèmes-là, le débat politique, au sens large du terme en l'espèce, va évidemment être sérieusement endommagé, je dirais, par cette restriction. Et puis ensuite, on assiste dans la jurisprudence de la Cour à une espèce de prolifération de la question d'intérêt public. Une prolifération qui paraît à un certain moment devoir être illimitée. Il y a le service de nuit des vétérinaires à Hambourg, il y a la qualité des soins dans une clinique de chirurgie esthétique, il y a la question de l'innocuité ou pas des fours à micro-ondes, il y a la question des débats qui existent au sein du département d'une université, etc., etc. On peut remarquer d'ailleurs, à propos du dernier exemple, que le fait que la communauté intéressée soit une communauté réduite ne change pas les choses. Pour la communauté concernée, c'est-à-dire pour les membres du centre de recherche universitaire en question, il peut évidemment, il doit être possible de porter à la discussion commune un certain nombre de questions. Elles peuvent donc être caractérisées comme étant d'intérêt général. Expansion illimitée jusqu'au jour du premier arrêt von Hanovre contre Allemagne, l'arrêt numéro 1, qui est donc un arrêt extrêmement important de la Cour, parce qu'il marque, ça a beaucoup frappé en 2004 les observateurs à l'époque, il marque une espèce de césure dans la jurisprudence de la Cour sur la liberté d'expression. Voici que tout à coup, la Cour dit non, là, on n'est pas dans le débat d'intérêt général. Et elle le fait, entre parenthèses, et je rejoins là les questions qui ont été discutées tout à l'heure, notamment par Eric Barent et Dieter Grimm, elle le fait en se posant véritablement comme une instance de contrôle pratiquement illimité par rapport aux juridictions allemandes, à savoir la Cour suprême et la Cour constitutionnelle fédérale allemande, qui toutes deux s'étaient prononcées dans cette affaire. Il s'agissait de reportages illustrés de photographies, sans quoi ils n'eussent pas eu beaucoup d'intérêt, sur la princesse de Hanovre, autrement dit Caroline de Monaco, pour les plus âgés d'entre nous, dont je suis malheureusement. Reportage sur sa vie privée, ses amants supposés, ses divertissements, etc. La princesse s'adresse aux juridictions allemandes en leur demandant de protéger son droit au respect de la vie privée et familiale. Les juridictions allemandes décident effectivement d'interdire un certain nombre de photographies, notamment celles présentant la princesse avec ses enfants, mais pour le reste, estiment que la princesse est une personnalité objectivement dans le débat public, qu'on ne peut que constater que la presse people, comme on l'appelle, est une presse qui est très lue, plus que la presse juridique, par exemple, et que les lecteurs de ces magazines sont tout à fait friands de détails sur les personnalités en question. La Cour allemande, la Cour constitutionnelle fédérale notamment, ne juge pas, elle constate. Elle se place d'un point de vue, si je puis dire, sociologique. Elle constate que ça intéresse les gens, que se produisent des phénomènes d'identification des lecteurs par rapport à ces personnalités, en l'espèce la princesse, et donc qu'il est légitime d'informer le public, même si ça peut apparaître frivole. Les cours allemandes ne se permettent pas d'en juger. Elles estiment que la liberté d'expression doit ici jouer, fût-ce au détriment du droit au respect de la vie privée et familiale. La Cour européenne des droits de l'homme va conclure tout à fait inversement. Elle va considérer que l'article 10 a été violé. Elle relève que la princesse n'occupait aucune fonction officielle pour la principauté de Monaco. Elle relève, dans une démarche donc, qui, à l'inverse de la démarche des juridictions suprêmes allemandes, est une démarche normative. Il y a ce à quoi le public doit pouvoir s'intéresser et il y a, si je puis dire, ce qui ne le regarde pas. La Cour indique que cette publication litigieuse avait eu pour seul objet de satisfaire la curiosité d'un certain public sur les détails de la vie privée de la requérante et serait passé pour contribuer à un quelconque débat d'intérêt général. Autrement dit, la Cour fait très nettement le départ entre, je le répète, des questions réellement d'intérêt public, notamment celles qui se rattachent au débat politique de quelque manière, et les questions de pur divertissement, comme elle le dira aussi plus tard, qui font l'objet d'une protection accrue, du coup, du droit à la vie privée et familiale. Les juridictions allemandes vont accepter ce point de vue, autrement dit, elles vont se ranger aux raisons de la Cour européenne des droits de l'homme, et elles vont donc modifier leur jurisprudence de manière à se placer du point de vue de la juridiction européenne. Mais, bien entendu, ça n'exclut pas les demandes de la même requérante, de la princesse de Hanovre à nouveau, et on va avoir un arrêt, cette fois-ci en grande chambre, dans la formation la plus solennelle de la Cour européenne des droits de l'homme, un arrêt von Hanovre numéro 2 contre Allemagne. La Cour européenne des droits de l'homme prend acte de ce que les juridictions allemandes ont fait leur, les critères qu'elle avait posés dans son premier arrêt von Hanovre. Et elle indique, dans une promesse qui me paraît vaine, mais c'est une promesse quand même, que lorsque les juridictions nationales procèdent d'une part à un examen minutieux de l'affaire, d'autre part procèdent à un examen de l'affaire dans le respect des principes indiqués par la Cour européenne, alors son contrôle va être plus léger et elle va s'en remettre davantage, on retrouve la marge évidemment nationale d'appréciation, elle va se remettre davantage aux appréciations des juridictions nationales. Et donc en l'espèce, la Cour conclut que contrairement à ce qu'alléguait la princesse, l'article 8 n'a pas été violé. Sauf que, en réalité, le contrôle de la Cour européenne des droits de l'homme reste un contrôle extrêmement minutieux. La Cour, dans l'arrêt von Hanovre 2, énonce un certain nombre d'éléments plus nettement qu'elle n'avait fait auparavant, qui doivent être pris en compte en cas de conflit entre la liberté d'expression et le droit au respect de la vie privée et familiale. Autrement dit, elle reformule son critère d'une manière très claire. Et d'autre part, deuxièmement, en réalité, elle épouse totalement le point de vue des juridictions allemandes, y compris dans ce qu'ils avaient en l'espèce de plus curieux, de plus critiquable, à savoir le fait de dire que oui, mais le reportage, cette fois-ci, sur la vie privée de la princesse de Hanovre, se produisait à un moment déterminé, le moment où le prince régnier de Monaco, qui était le prince régnant, était malade, et donc on se rattache à un débat d'intérêt général, qui est la question de savoir quelle est l'attitude de la fille du prince régnant par rapport à la maladie de son père, égale, ça n'empêche pas de partir en vacances. Le débat d'intérêt public m'échappe, mais en tout cas pour la Cour européenne des droits de l'homme comme pour les juridictions allemandes, il peut être considéré comme établi. Arrêt du même jour, un arrêt Axel Springer contre Allemagne. Cette fois-ci, la Cour va conclure sur la base des mêmes problèmes. Je n'ai pas le temps de faire allusion au fait de l'affaire, on pourra y revenir si vous le voulez lors des questions. La Cour européenne des droits de l'homme, cette fois-ci, conclut à la violation de l'article 10, alors que les juridictions allemandes avaient appliqué les mêmes principes et avaient raisonné d'une manière qui avait conclu à une conclusion d'interdiction de publier un reportage à propos d'un acteur qui incarnait un commissaire de police dans une série télévisée. Au-delà de l'identification des questions d'intérêt général, donc il y en a de plus en plus, et finalement l'arrêt von Hannover 1 n'a pas été vraiment un point d'arrêt à cet égard. Quel est le régime juridique qui s'applique à ces questions? La réponse, c'est qu'il n'est pas du tout fixé et qu'il n'est pas du tout clair, je dirais. Il y a des limites à la liberté d'expression, même, j'allais dire surtout parfois, sur les questions d'intérêt public. Ce n'est pas parce que vous êtes dans un contexte électoral que vous pouvez dire n'importe quoi sur les candidats à cette élection. Vous ne pouvez pas, ça a été fait en France il y a 5 ans, inventer des comptes à l'étranger que détiendrait un candidat alors qu'il n'y avait aucune, et qu'il n'y a eu depuis d'ailleurs aucune, base factuelle pour cette affirmation. Vous ne pouvez pas non plus, à propos de débats d'intérêt public, tenir un discours de haine, un hate speech, on en a parlé tout à l'heure. On est bien dans la matière d'un débat d'intérêt public, mais encore une fois, on ne peut pas raconter n'importe quoi dans le cadre d'un débat d'intérêt public non plus. Encore une fois, on ne peut pas inciter à la haine. Alors, je suis d'accord avec la proposition d'Éric Barren tout à l'heure, c'est que le hate speech peut être dans le performatif, dans un performatif éventuel, c'est-à-dire très largement supposé, parfois fantasmé peut-être par le juge, qu'a dans pas mal d'affaires contre la Turquie, dans le contexte que j'ai dit tout à l'heure, dans le contexte de la question kurde. Et puis, il y a la référence de plus en plus importante de la Cour européenne des droits de l'homme à la déontologie journalistique. Autrement dit, il y a un minimum, et d'une manière plus générale sans doute, de la déontologie de ceux qui s'expriment. Encore une fois, on ne peut pas se prévaloir de la liberté d'expression pour raconter n'importe quoi. Il faut un minimum de base factuelle. Il faut, alors, quelle étendue, il y a beaucoup de flottement dans la jurisprudence, mais enfin, il faut un minimum de base factuelle, une base factuelle suffisante, dit la Cour européenne des droits de l'homme, ce qui est évidemment un standard un peu vague, mais forcément, on ne peut pas poser ici des règles a priori très précises. On ne peut pas mentir délibérément, sauf lorsque on est dans une question vraiment sans intérêt, qui est une question d'intérêt public purement formelle, et encore, on doit, autrement dit, même dans le cadre d'un débat d'intérêt public, même dans le cadre d'un débat d'intérêt politique, respecter un certain nombre de règles du jeu, parce que la société démocratique, c'est une société qui repose sur la raison aussi, sur un débat qui s'établit sur des bases, je dirais, d'une décence minimale. On ne peut pas admettre les tricheurs. On retrouve le problème des fake news. Par association, on retrouve le problème du compte Twitter de Donald Trump. Il y a des limites de ce qu'on peut dire dans une société démocratique. Et ce n'est pas parce qu'on impose ces limites que la société cesse d'être démocratique. Je dirais très souvent au contraire, à condition évidemment, et la Cour européenne des droits de l'homme en est l'ultime garant, avec évidemment toujours le caractère délicat des arbitrages, le caractère forcément subjectif de la décision à un moment déterminé. Ça, c'est commun à tous les juges, qu'ils soient nationaux ou internationaux. Mais en tout cas, il y a ici une jurisprudence qui est avant tout libérale, il faut quand même y insister, mais avec des limites difficiles encore une fois, à prévoir d'avance. La sécurité juridique n'y trouve peut-être pas son compte, mais là encore, je crois que c'est une fatalité. Voilà, je dirais pour l'essentiel cela, en vous priant encore une fois de m'excuser pour m'être exprimé en français.
Thank you very much to Patrick Wachsmann. And so with that transition, I give the floor to Helen Norton, who's professor of law at the University of Colorado. Thank you so much for being here, Helen, and for accepting to make some comments on Johannes and Patrick's presentations.
Thank you so much for inviting me to be a part of this discussion. I'll keep my remarks brief, and I'll identify some common themes and concerns among Professor Wachsmann and Professor Masing's papers, themes and concerns that also appear in United States First Amendment law, and I'll also try to identify some divergences and some issues yet to be discussed. So I'll offer a few perspectives from First Amendment law, not because those perspectives are always coherent, but instead to illustrate other ways of thinking about these sorts of problems for better and for worse. And I'll invite the panelists' response to some of those concerns. So in discussing the structure and the boundaries of public debate, I understand Professor Masing and Professor Wachsmann to be addressing the foundational questions of what free speech law protects and why, how law protects free speech, whom free speech law protects, and from whom free speech law provides protections. So, for example, Professor Wachsmann is interested in what I'm calling the what and the why of free speech. In other words, whether and when the subject matter, the content of expression is a matter of public concern, a matter of public interest, such that it should be protected to further democracy. Now, Professor Wachsmann focuses on the case law from the European Court of Human Rights, and he notes the court's difficulties in defining the outlines of this very broad concept of speech on matters of public concern, public interest, and U.S. First Amendment law reflects these same challenges. What free speech law protects, or should protect, turns on why we protect free speech. In other words, it turns on the justifications for free speech. The American First Amendment tradition identifies multiple justifications, including, but not limited to, democracy enhancing. And because of these multiple justifications, the First Amendment tradition protects not only public concern speech defined quite broadly, but also lots of other speech. Under this expansive tradition, speech is presumptively treated as protected by the First Amendment, to be sure, with some important exceptions. But even within the exceptions, this concept of public concern does important work. For example, the United States Supreme Court relies on distinctions between speech on matters of public concern as opposed to private concern in assessing First Amendment claims by public employees. Whether public employees' speech is protected from discipline by their government employer turns in part on whether that speech is a matter of public concern or instead more akin to a private grievance. And the Supreme Court denies a tort plaintiff's ability to collect damages for speech that intentionally inflicts emotional distress when that speech is on a matter of public concern. And so too do the First Amendment rules that United States courts apply to defamation claims depend in part on whether or not the contested speech is on a matter of public concern. But even though this concept of public concern speech does important doctrinal work in a number of First Amendment settings, we have no precise definition of what that means, nor do I think a precise definition is probably possible or wise. The U.S. Supreme Court has indicated that speech involves a matter of public concern when it, quote, is a subject of legitimate news interest, a subject of general interest, of value and concern to the public. Very capacious. At the same time, the court has also observed, quote, the boundaries of the public concern test are not well defined. seems to be the case in the European Court of Human Rights as well. Now, again, this question of what speech, free speech law protects, like public concern speech, and how broadly or narrowly we should then understand public concern speech depends in large part on why we think law protects speech. And that question of what free speech protects then leads to the question of how law protects free speech. In other words, the breadth of free speech protection may affect the depth and the mechanisms of free speech protection. So along these lines, First Amendment scholar Fred Schauer has observed that jurisdictions with an expansive understanding of the coverage of free speech, jurisdictions that take a broad view of protected expression, in his view, turn out to have a significantly less stringent degree of protection for that speech, even for the speech that lies at the core of the free speech principle. So in other words, under his view, as a pragmatic matter, the more speech that free speech law protects, the less robust, the less strong that level of protection. Now, accurately or not, many in the United States understand the European free speech tradition, which, as the panelists noted, often rely on proportionality, what some might call balancing. Many in the United States, accurately or not, understand this European free speech tradition to provide a lesser amount of protection than that provided by the U.S. tradition, where the Supreme Court generally asserts a preference for bright-line speech protective rules like strict scrutiny that's deeply suspicious of the government's regulation of speech. Here too, of course, there's all sorts of exceptions. But one question that I'll pose this one primarily to Professor Wachsmann, but I'm certainly also interested in Professor Masing's view, is to invite commentary, observations as to whether Professor Schauer is right to suggest that the more speech a free speech tradition protects, the less robust the degree of that protection. Does that assertion accurately describe the European tradition? In other words, has the strength of free speech protection ebbed and flowed with the breadth of protection? The more that the tradition protects, do we see less protection? Now, the panelists also addressed the need to balance the competing interests of speakers and targets when certain speech may be of public interest, yet may also threaten private interests like privacy or reputational interests. And I think it's important to acknowledge similar tensions, like those between speakers and listeners, that also raise important questions about whom free speech law protects. Speakers, for sure, but listeners too, as speech also serves listeners' democratic self-governance interests, as well as their autonomy and enlightenment interests. And Professor Masing's remarks addressed related concerns. Many difficult First Amendment problems include clashes between the First Amendment interests of speakers and listeners. I'm thinking, for example, of situations where speakers want to keep secrets, but listeners want disclosure. I'm thinking of situations where speakers want to tell lies, where listeners instead want the truth. And I'm thinking of situations where speakers want to talk, when speakers want to be let alone. How should free speech law handle those conflicts? In the United States, contemporary courts presumptively favor speakers over listeners when those interests collide. But here too we can find exceptions to the rule, as there's other strands of doctrine that privilege listeners' interests in certain circumstances. And Professor Masing made a related observation when he talked about the role of fundamental rights in counteracting imbalances. So along those lines, First Amendment law has long favored comparatively vulnerable listeners over comparatively knowledgeable or powerful speakers in certain contexts, like commercial speech. And the U.S. Supreme Court has also recognized that listeners' interests sometimes justify interference with speakers' interests, even within public discourse, even within public concern speech, when doing so furthers those listeners' interests. And here I'm thinking, as one of several examples, of campaign disclosures, where the Supreme Court has held that listeners' interests, voters' interests, in knowing the source of campaign contributions and knowing the identity of campaign communicators sometimes justifies requiring those campaign speakers to identify themselves publicly, even if those speakers would prefer not to. In other words, greater attention to listeners' interests help explains not only when and why the First Amendment protects speech, but also when and why the First Amendment permits expressions regulation in certain circumstances to protect listeners in ways that preserve meaningful discourse and democracy. Now, Professor Masing is also interested in the justifications for protecting speech from encroachment not only by the state, but also by other private actors. And here I understand Professor Masing to be raising important questions about who and what threaten free speech and democracy. The government can do so, of course, and in a variety of ways, but not just the government. And the United States, too, this increasing awareness of the ways in which private power can threaten free speech and democracy has led many commentators to call for legal and other mechanisms to encourage powerful private actors to incorporate democracy-promoting approaches to their own speech. And this problem is such that First Amendment scholar Tim Wu has wondered whether First Amendment law is now obsolete, outdated. More specifically, he observes that the 20th century development of traditional First Amendment law relied on the premises that speech is limited, that listeners' attention is unlimited, and that the government is the only threat to free speech through its regulatory ability to censor, to choke off speech. But with 21st century speech technologies, Professor Wu observes, speech is abundant. It's listeners' attention that's limited and overtaxed, and private power is understood to pose a threat to free speech and democracy along with the government. So this leads Professor Wu to wonder whether the First Amendment has the tools to solve the free speech problems of the 21st century. And so here I'll pose a question primarily to Professor Masing, but I'm also interested in Professor Wachsmann's views about whether the European free speech tradition has tools to address these 21st century conflicts between speakers and listeners, between private power and free speech, that perhaps the American tradition lacks. Thanks again to Professor Wachsmann and to Professor Masing for giving us so much to think about, and I look forward to the continued discussion.
Well, many thanks to you, Helen, for this very stimulating comment. Johannes and Patrick, you can respond. Do it briefly if possible so that we have some time left for general discussion. I don't know which one of you wants to start. Patrick, go ahead.
Merci beaucoup pour ces observations. Oui, je crois qu'il y a une différence fondamentale entre la conception européenne comme...
Helen, do you understand French? Or do you want me to... I'll translate in the chat.
Oui, je vais essayer alors en anglais, mais je ne sais pas si vous comprendrez davantage. I agree with the difference between European and as in the case law of the European court law and American conceptions of freedom of speech or liberté d'expression. But I think the main difference is perhaps on the hate speech. I think it is a very important matter for European conception because of the experience of the pre-war disintegration of democracy, of the Weimar regime, with its inability to regulate extremist discourses. And so with the German federal regime in 1949, we have a streitbare Demokratie, a democracy who allows itself to fight against his adversaries and to give itself the means to avoid this perverse utilization of freedom of expression. And so I think it is the main reason why there is such a difference between European and American approach on the question of hate speech. In the US, you can have demonstrations in favor of Nazi sympathisants, even in zones where there are a lot of survivors of the Holocaust. In Europe, it's considered as unacceptable. So I think we have on the basis a very different historic experience that can explain not only that, of course, the difference. On the subject of conflict between right to respect of family and private life, it is also a difference between the continental conception in Europe and the common law conceptions, which are less favorable to the rights to privacy than the continental one, which is always looking for establishing a fair balance between the two competing rights. So maybe it could be explanations on the reasons of the differences. Thank you, and I apologize for my English.
Johannes?
Yeah, thank you very much for your very thoughtful questions. I will start with a question, what I think about the thesis that the more fundamental rights protect, or the freedom of expression, or the broader we understand it, the lower is the level of protection. That was a little bit one question you asked, if I understood well. I think the question is not correct, because that would be a correct question if you've asked, or if you start with the idea the protection of freedom of expression is the same in every field. That would be, your thesis would be true. If you have a broad scope of protection, the level has to be lower. But I actually wanted to show in my contributions that if you differentiate between the different fields, you can have a very strong protection. Let's say for political speech, we have a very strong protection. There are some exceptions, but they are not due to the fact that we have already also a protection of private persons and labor law, for example. That has nothing to do with that. We have a very strict protection there. Content-based limitations are generally not allowed. That's very close to the American, and we are stricter than most European states in this respect too, I would say. But we have a broad scope of legal protection, for example, also labor law, and of course, as so far as fundamental rights and as so far as freedom of expression is protected always in relation of labor law, of course you have to accept other rights which have to be balanced with that. And in this relation, the level of protection is quite different than the level in political speech. And you can generally say that I tried to emphasize that private speech has much more limits, and the level of protection is lower than in political speech. But I wouldn't say, because we have a broader scope of application of freedom of expression, that means that in every case freedom of expression will be less preserved or on a lower level preserved. It depends. And my point of my whole contribution is we have to look at the specific fields of freedom of expressions. The second point, you asked me if we have a great interest in the listeners. There are two, I would say. It's interesting. You spoke about speakers and listeners. I spoke about speakers and affected persons. And I think that's a difference, because not every listener is an affected person, affected in its own fundamental rights, because very often listeners may have interests, of course, but they are not affected in the sense that they are possibly injured in their own rights. If, as far as they are possibly injured in their own rights, perhaps we have a great interest in them, but this also is linked to the fact that we have a broader scope of application of the fundamental rights of freedom of expression, extending them to private relations too. And your last question, I have to be brief. If we have tools to address the challenges ahead in the kinds of internet, well, I would say the tools themselves are very technical tools which has to be developed only. But from a fundamental rights perspective, we can look to the different institutional requirements we have developed on the basis of fundamental rights protection. Looking at, if you look at my article I wrote about broadcasting, the broadcasting regime is a little bit outdated today. We have to change it completely. But you can see we have institutional requirements, and we derive from freedom of expression that there have to be institutions, regulations, and something of that. And we have perhaps the tools in this sense. The court can say to the legislator, you have to do something to get to a balance, and you have to come to certain minimum standards. How far these techniques will work out, we don't know still. We have to develop this. And today in my small contribution on the internet, I wanted to show at least we are starting to develop it. Yeah. So the service providers have to respect the fundamental rights of the users, but not in the same way as the state. And the state has to provide procedural structures that every side can be heard and have its needs. And I think we have to go on in this way. And there are many, many other challenges. We don't have any answers until then. But our broad idea of fundamental rights as principles entitle the courts and entitle us to discuss which means are possible to realize some meaningful freedom of expression even on the world of the internet. And this has to be done not only, this is not only a subjective right of the single person, this has to be done, but it is something which has to be developed by the legislator together with the courts and an application of the simply law in the light of the fundamental rights of the different persons, even if these are completely private relations. And I think with this, we can go forward. I'm not so clear to what extent this would be possible in the United States too. So I cannot say anything about the United States, but I just can think we have a basis from which we can push the development. And I think we must push development in order to preserve a meaningful freedom of expression on the internet. Thank you.
Thanks to both of you for your reaction to Helen's comment. We have a first question by Georges Letsas.
Thank you. I have a comment and a question for Professor Masing. The comment was prompted by Professor Norton's observation about the relevance of public interest in the First Amendment jurisprudence and the comparison with Europe. And it seems to me that even though there is a clear parallel there, there's a crucial difference. It's one thing to invoke public interest or public concern as an exception within a private relation, either of employment or tort, which is the case in the First Amendment, and a different thing to raise public interest in the context of criminal law by way of allowing criminalization of speech, because it doesn't really relate to public interest issues, which has been the case with many cases of the European Court of Human Rights with hate speech and lowering the protection because the area under which the speech falls doesn't relate to matters of public concern. So there, what you do is you carve out a protection against criminalization of speech. That's a different context to talking about public interest in the context of public employees or the tort of emotional infliction of distress. So that's the comment, and that's why I do think that the European Court idea of public interest is very problematic, unlike the US one. But my question is for Professor Masing, and the question relates to the Facebook case. So you rightly raised the concern about the interest, the rights of speakers and users, and what will happen if Facebook and all the other private companies employ an approach whereby they don't allow views that are on some level extreme or unpalatable or beyond the pale, and what will happen to the internet as a result of that, which I think is a very valid concern. But it seems to me, at least on the empirical level, that's not really happening insofar as there are other platforms where people with those kind of views can go. Could be Reddit, could be Breitbart, could be, I don't know the platforms or the forums, but there are very many alternative right and left platforms where people with non-mainstream views can go now. And then the question is whether we worry about Facebook and Twitter being the dominant one in terms of numbers. Now, Professor Norton says, well, the problem now is the limited attention span. It's not really the availability of the speech, rightly. It's how much we pay attention. So if most of us use Twitter and Facebook, and these platforms are controlled by the companies in a way that blocks out certain views, it's not a problem. Now, my question to you is, why should we think this is a problem if all of us speakers are aware of the algorithms, are aware of the filtering, are aware of the standards, and can choose where to go? Shouldn't we just accept that people are informed, autonomous beings who can make choices? I'm not on Facebook, I'm not on Twitter, because I know that's what they do. And I choose which platforms to visit and where to express my views. Shouldn't we expect of people to show this kind of judgment? Insofar as there are platforms there available for any kind of speech. And there are, extreme websites or extreme platforms where they will post anything. So should we worry about the impact of Facebook and Twitter on the attention span of users, or should we trust users to make choices?
You want to respond?
Yeah, it's an important question, and indeed, I stressed that I took on a long time perspective. In the moment, we have rather the opposite problem. We have very brutalized platforms in high quantity, but I see that regulation is going to push them aside and even to stop them. And as far as we have a choice, so I emphasize, if the market dominant platforms effectively extinguish the possibility to express other views, this is a problem. But there we have another big challenge for a democratic society. We have to keep together. We have to get to an exchange between the different worlds in which we are. And I see at the moment we are becoming very different communities which are less and less interacting with each another. And this is still another challenge I didn't mention until then. You're completely right. I didn't mention it, but that's another challenge for regulation. How can we get together the different communication form? And there I don't see any solution until then. But I think this is a big challenge by regulation, which there are many debates in that about the algorithms, for example, that they cannot exclude too much things. And so I think that's another kind of challenge which also can be invoking freedom of expression, be regulated at a certain extent, but it has always to make clear that all kinds of expression have to have a possibility to be expressed. And as long as we have Breitbart and all these platforms, I agree, we can give leeway to other platforms to reduce that. Of course, we can. And so for me, it's very important if it's a market dominant platform or not. And so at the moment, everybody is very happy with, not everybody, but many people are very happy with the solution of the Federal Court of Justice, who said, Facebook, if it wants to make a good field atmosphere for the users, go ahead, and just pushing them. But we have to see the state can nudge them, and that's actually what it's doing. Yeah, the state is nudging them and saying, please, we give you these rules, and they are going beyond these rules because they want to be responsible and they want to have any liability against the state. So they reduce the legal standards and create the private standards, which are lower than the states, as a lower in the sense they admit less plurality. And this is pushed and nudged by the state. And I think I don't feel very well with that. I don't have a definite answer on that. And I see your point, and I agree with it. As long as we have enough possibilities for on other platforms to express its concerns and opinions, that's not such a problem. Yeah. All right.
I think Christoph wanted to follow up on this very point.
Thank you so much, Sean. I would like to thank all the panelists for wonderful talks and that were very inspiring. But I perfectly see what George is getting with his point, and I buy into it at least to some extent. However, the question is whether the plural itself is not the problem. Typically, if we were talking about digital fragmentation, we would discuss it. I think Professor Masing has hinted to it, or at least alluded to it, about forum internal phenomena. So there is not just one Twitter, there is a large variety of Twitters that would serve as echo chambers for the respective users and so on and so forth. They would reinforce their views, etc., and this would all spiral down. Okay, fine. And certainly the informed user, enlightened as she may be, may choose to use a certain platform or to move to another if she should decide not to be content with the services that was offered. However, does that really solve the problem? Because if this is the way we approach this, in the end, what we create is not fragmentation, or what we have to tackle is not fragmentation within a single forum, but it is a fragmentation of fora that coexists next to each other, and that in the end would provide us with a situation of a fragmented public, evidently, that certainly cannot be considered the ideal of any kind of public deliberation worth its salt, in that it happens between individuals interacting within the same marketplace of ideas. So I think Professor Masing has a perfect point when he says the only way to actually tackle this is to approach the dominant players that are at stake, because dominance is as such perhaps not creating a single market of an exchange of ideas. However, it is the closest we can get to such a single market of an exchange of ideas, simply because it is the closest we can get to establishing one forum where opinions can meet, and that would still leave us with various challenges of fragmentation, echo chambers, and so on and so forth. However, it would not from the very outset accept different fora coexisting next to each other.
Do you want to respond?
Me?
Yeah, you don't have to.
Yes, I feel understood very well. It's exactly the point. I think the dominant market has to be open enough. If we allow to close up very much even the dominant markets, and we will further the disruption between the different markets, and this is not helpful. But I agree completely with what you said.
Helen, did you want to follow up on the conversation, or are you good?
Good, thank you.
Okay. Thank you so much to Johannes Masing and Patrick Wachsmann for their presentation, and for Helen Norton for the discussion. Thank you to all the participants to today's panels. That's it for today, but we'll meet again tomorrow morning at 10:30 Paris time, or Lyon time, for a panel with Helen Fenwick, Oreste Policino, Marco Bassini, and Adrian Stone. and then for 2 more additional panel in the afternoon. So thank you to all. Have a great evening, afternoon, or morning, depending where you are right now. And we'll see you tomorrow. Bye-bye.